Well, welcome everybody. I'm glad to see all of your bright and shiny, smiling faces. It's going to be an exciting day today. We have with us Ms. Gretchen Ortiz, and Gretchen is not only a FRI agent like all of you, but she is an accomplished attorney, teacher, accredited for CEs, everything else, and she is wonderful. Part of the FAR bar people and all that kind of stuff. So she knows what she's talking about, and she's here to talk to you guys today about probate and what it means to you and what it means to your clients and how to handle it and how to not mess it up and how to work with someone like her. So I'm going to turn it over to Gretchen, and thank you so much for coming. And I will make you, do you have something to share, like screen share, Gretchen, or do you?
Yes, I'm going to be sharing a PowerPoint.
Okay, I will make you the host right now.
Perfect.
And welcome.
Thank you.
The floor is yours.
Good morning, everyone. My name is Gretchen Ortiz. Like Ryan said, I'm a real estate attorney. I practice in the areas of contracts, real estate, business, and also probate law. I've been in the real estate industry for over 20 years. And so now I combined both my knowledge and my legal experience to bring everyone the best service possible. So today we're going to be talking about probate. And this is a very important topic. I'm going to be talking about cases and about what has been trending this past year. As you all know, we've been facing the pandemic since 2020, and a lot of realtors are facing death of their clients, and they don't know how to handle it. So we're going to be talking a little bit about that. If you have any questions, let's wait until the end, and then I'll try to get to as many questions as possible. So I'm going to share my screen. Just a minute. Can everyone hear me fine? Because unfortunately, my desktop decided it was going to update just 5 minutes ago. Good? Okay. Perfect. Okay, so what are the probate issues facing realtors today? What is going on? Here it is. Okay. Okay, so this is just a normal disclaimer. This is intended for educational purposes only. If you or your clients find yourself in a legal situation, please contact an attorney. And this information that I'll be providing to you today, it only applies to Florida. Okay, so let's dive right in. So what is probate? Probate is a legal proceeding, is very, very complex. And it's what happens after a person dies. In Florida, whether you die with a will or without a will, you have to go through probate in order to determine the beneficiaries, who are the beneficiaries, who are the heirs, how property and assets is going to be distributed to those heirs and beneficiaries, to pay off the debts of the deceased person. So a lot of realtors ask me, well, if there's a will, can we just bypass probate? No. In Florida, like I said, with a will or without a will, we still have to go through the probate process. And even when there is a will, it has to be approved under the discretion of a judge. So that has to be submitted to the court system. There's different types of proceedings as far as probate is concerned. So we have the one that's called the formal administration, and that's when the assets of the deceased person exceeds $75,000, not including his primary residence. And then we have the summary administration, which is the one where the assets are less than $75,000. This is not including the primary residence. And we have the ancillary proceeding. I have a lot of real estate agents that are working with foreign sellers and foreign buyers, and unfortunately they need to go through a probate proceeding, and we can do that if they have property in Florida through the ancillary proceeding. So as far as time frame is concerned, the formal proceeding usually before the pandemic, it was taking 6 to 9 months. Now that since 2020, it's been taking almost 2 years. So from anywhere from 12 months to 18 months. Yeah, I will say is the average. However, you don't want to lose contact with the attorney. You don't want to lose contact with your client, because that doesn't mean you're not going to be able to sell the property until the probate is done. No. The first thing we do as an attorney after we open the probate proceeding and we get letters of administrations and we get all the paperwork that we need is get an order authorizing the sale of that property if that is something that the beneficiary is going to be able to do. And that can take anywhere from 3 to 4 months. And in 4 months, you can list that property. So a lot of the issues that I see with realtors is that once they refer the client over to an attorney, or once they know that there's a probate proceeding that has to be going through, they lose contact. They stop their relationship with the client. They don't keep a relationship with the attorney. And unfortunately, we have to find another real estate agent. So one of the key benefits of understanding probate and understanding this proceeding and understanding what you can do is that you can keep that relationship with the attorney, with the client, and get the listings. And sometimes there have been cases that I've had where the client ends up with more than one property, and so the realtor gets more than one listing. So you always want to keep that relationship with the client. Also, you want to be able to provide whatever information you need to provide from the beginning. So we're going to get into that in a little bit. But for now, it is just know that probate is very complex. So if you face this, you don't want to get yourself involved. You don't want to give any legal advice, and understand that even if the client tells you, well, there's a will and the property is mine, you don't want to get into any of that. And there's different types of proceedings: formal, summary, and the ancillary proceedings. Okay, so let's talk about a little bit about the cases that I've had in the past 2 years with issues the realtors have been facing with probate. So the first one is improper transfer. So I recently had a real estate agent call me. They were at the closing table. So they had gone through the contract. They were at the closing table. They were getting ready to close. I believe they even closed. Yeah, they had closed the day prior to the day they called me, because after they closed, the underwriters found that there was an issue in title. So there was a buyer and a seller. They transferred the property to an LLC, and then the LLC sold to the seller that was at the closing table, and then the seller sold to the other person. However, the one that transferred the property over to the LLC was the wife. The husband never transferred the property to the LLC, so he still had an interest in the property because the transfer wasn't done properly. It was done, unfortunately, by someone that wasn't an attorney. And what happened was this: since the husband had not signed for that property to be transferred to the LLC, that was a break in the chain of title. So they had to go back. We had to go back and find the husband. By that time, he had passed away. So we had to go through probate to get that taken care of, so that transfer was properly done, and every other transfer, and then do a quiet title action to fix everything that happened after that, so that this transfer that was done on the closing table was able to go through. So these are some of the issues that our realtors are facing as far as probate is concerned. So another issue is quick claim deeds. So a lot of real estate agents tell their clients, well, yeah, you can transfer the property to an LLC, or yes, you can transfer the property to, or you can add your son, or you can remove your son. But all of these things have legal and also tax ramifications. So you don't want to give that type of advice. You always want to say, speak to an attorney regarding a transfer, or if you have any questions regarding taxes, speak to an accountant. Why? Because quick claim deeds cause a lot of problems when it comes to probate. Just because a wife and a husband have been separated for a long time, and the husband did a quick claim deed to the wife, does not mean that the wife owns the property. Fee simple. If they are not divorced, meaning they have a judgment signed by the judge with a divorce decree, then they're technically married, and the husband still has to sign. So a lot of quick claim deeds cause problems because the listing agent lists the property goes under contract. The listing agent is sure that the wife or the husband is the owner of the property, and then they get to the closing table or they close and there's an issue with title. So quitclaim deeds have been a lot of problems this year. The third cases that we're seeing is the one with LLCs. LLCs transfers because it is either the wife or the husband that transfer the primary residence to an LLC. And they do this for different reasons. Sometimes because they're getting ready to move out and they want to rent the property. Other times because they want to minimize their liability. Other times it's because they want to assign it to a trust. And other times it's because they want to protect their assets. But if the transfer is not done correctly, then if one of them dies, there's an issue with title. And so the property has to go through probate. And so the other reason, the other issue that I've seen recently is where realtors are advising clients after closing, you can transfer the you can transfer the property to an LLC. However, the mortgage there's a clause that states clearly that that can't happen. So lenders are catching up to these things and they're putting those clauses into mortgages. They're having the buyers sign this document stating that they're not going to transfer properties to any LLCs. And so then the buyer has an issue and they call me and I have to represent them. And they were given that advice by a real estate agent. So one of the things that you can do is never give any legal advice. Never advise a buyer on what to do with it quickly in the LLC. Just take the liability off of you and just have them speak to an attorney or to an expert. I always tell every agent that the best thing they can do is have a team of experts to work with, an accountant, an attorney that they know, so that if they have any questions, they can just have their client call them. The fourth issue, and I think I touched a little bit just a few minutes ago, is divorce cases. And it's where the wife tells the real estate agent, well, I've been separated for 20 years. He moved out of the country. There's no legal separation in Florida. There's only two statuses in Florida, single or married. That's it. You're either single or you're married, or you're either single or divorced. And if you're divorced, you have to have a judgment signed by the judge. A marital settlement agreement doesn't work. A legal affidavit by the husband or the wife doesn't work. It has to be a divorce decree. It has to be signed by a judge. It has to be recorded in order to be effective. So one of the issues that I faced just a couple of weeks ago is where a buyer, unfortunately, was not able to purchase the property. They wanted to sue the seller because the seller technically was married. The listing agent listed the property. They had been separated for over 20 years, and the husband had moved out of the country, but that did not mean that the wife was single. She was married, and he had to sign, and there was no way we can find him because he had moved out of the country. But as per Florida law, he was still married. So if as soon as you're getting ready to list the property, if a person tells you, whether it's a husband or a wife, that they've been separated, ask for a divorce decree. If they don't have one, have them contact an attorney, a family law attorney, a real estate attorney, and let them handle it. Don't get yourself into that mess, and don't get involved in opinions in the relationship, because if you're going to become the listing agent and the husband has to sign, you want to make sure that you're unbiased and you have a good relationship with both. So you're kind of going to have to be the mediator in that situation. So a lot of issues with divorces. And if the husband has passed away and she's married, the property may not automatically transfer to the wife. I've had realtors say that to their clients. Well, if you're married, it's your primary residence, and that was your husband, it automatically transfers to you. We only need a third certificate. No, because if he has kids with another woman in a previous marriage, it may not work out that way, especially if there's not a will. So there's many factors when it comes into deciding how assets are going to be distributed. That's why probate is so complex, and that's why it is important that you do not give any type of advice and you have them speak to an attorney. Another issue is tenancies. So We have tenancy by the entireties, with, of course, is when we have husband and wife. And we have joint tenancy with right of survivorship. So I've had a lot of real estate agents call me because they've told their clients that automatically the property transfers to the wife in a tenancy by the entirety, or automatically transfers to the other owner in a joint tenancy with right of survivorship. But what happens is that sometimes there's 5 people that are holding title with joints with right of survivorship, and one of them broke the joint tenancy by either transferring their interest in a will, and unfortunately that creates a problem for everyone else, because in a joint tenancy, if you break the joint tenancy, it defaults to tenants in common. So again, even if you see a deed, or even if the person tells you, well, we're holding title as joint tenancy with right of survivorship, ask your client for the deed. And then ask your client to get in contact with these other owners, because sometimes they lose contact. They buy a property and they lose contact with the other owners. And those were some of the issues that we're facing this year, is tenancy. So don't give any legal advice. Request the right documents. If they tell you they're divorced, ask for a divorce decree. If they tell you that they're holding titles joint tenancy with right of survivorship, request a copy of the deed. And then contact an attorney yourself, or have the client contact an attorney. And last but not least, power of attorneys. So I would say 3 to 4 times a week, I have realtors call me to draft powers of attorneys for their clients. If powers of attorneys are not drafted by an attorney, and they're drafted by a LegalZoom, or they're drafted by, they're a template, unfortunately, they may not comply with all the legalities of Florida law, or they may be missing some clauses that needed to be on there, because a template is not particular to this person's case or this person's situation. And so we're running into a lot of issues with power of attorneys when confronting the death of a seller, or the death of one of the sellers. So you want to make sure you get the copy of the power of attorney, and either send it to the title company for the underwriter to review, or contact an attorney. Don't get yourself involved in giving that legal advice. Why? Because now we're going to talk about the listing issues. You list a property, you go under contract. As a real estate agent, you're supposed to have some knowledge and be providing that knowledge to your clients. And so yesterday I got a call from a real estate agent. They're under contract. There's closing, I believe, tomorrow. And she's calling me the day prior to closing to let me know, hey, listen, I just found out that there's not a divorce decree. And so here they are the day before closing. Everything's done on the buyer side as far as financing. They've met all of the requirements. So what do you think is going to happen here? There's going to be issues. They're going to be the buyers are going to want to sue for their rights. So they're not going to want to lose the property. So a lot of legal issues and a lot of money issues are going to be happening in this situation. So you don't want to get to a point where you have a contract in place to find out that you have that your seller has all these issues. So you want to make sure that you have all that information before. Every time I get a contract for either a closing or to review, I always look at the first is where it says the seller's name, and it never has the tenancy. It always just gives me one seller's name. And I always ask the real estate agent, were they married? Are they divorced? Are they single? So you want to have that in the contract so that you protect yourself. Second issue with contracts and probates is that the contract has the wrong parties. So like I said, they're either married, husband died, wife thinks she can sell the property because she's the wife, but the husband was previously married, had 3-4 kids. They want their share of the property. So they're starting a probate proceeding. She doesn't know. And so the wrong parties are listed. In a probate proceeding, the one that sells the property is going to be the personal representative, which can be the wife, can be the one of the kids, or can be someone appointed by the court. So the wrong parties may be in that contract. And or if the property was in a trust, it's a trustee. So I always see listing contracts where there's the wrong parties aren't there, or just the tenancy is not there, or the status of the seller is not there. Those three things are very, very important, and they're going to protect you as the real estate agent. Some realtors tell me, well, why didn't the title company tell me any of this? The title company is not an attorney. They're not there to tell you what to do or not to do. They're there just to close the transaction. A title agent is not an attorney. They can't give you any legal advice. They can tell you how your buyer is to hold title. They can only tell you the tenancies, provide you a document, and give you the definition. They can't tell you you should take title this way or that way. They shouldn't. That's crossing the line of the licensed practice of law, because there are legal and tax ramifications for that buyer on how they hold title. So the title company is not going to give you this information. And if the title company gives you that information, you want to make sure that they spoke to the underwriter and that they have that in writing, because the underwriter is the attorney, not the title agent. So I get that question asked all the time. Well, why didn't the title company find out that there was a probate proceeding? Well, if a death certificate wasn't filed with the court, the title company, when they did the title search, might not be aware that that death occurred. That is the listing agent's job to find out what's happening with their seller. So that's why you want to build a relationship first with your client and understand who your client is, what their status is, and what's going on with your clients. What does this avoid? This avoids lawsuits. So I'm going to tell you, in this market, I will say every week I get at least 3 to 4 calls, either from sellers or from buyers wanting to either file a complaint or sue the real estate agents because of legal advice, or because they're getting themselves into issues that they shouldn't get themselves into, or they're recommending things that they shouldn't be recommending. And so have your team, create your team. Your broker first. Your broker should know an attorney or have an attorney on your team, and obviously a financial advisor or a CPA. And I always say, when in doubt, contact your broker, and your broker is always going to tell you to contact an attorney. You also have access to a legal line with NAR, with the legal hotline. Always call them. But if you, as soon as you get on the phone call, you have to agree that they're just there to give you their opinion. You can't even use them to say an attorney told me this. So always, when in doubt, contact an attorney. So what to do if once you build your relationship with your client and you know that either the husband, whoever the seller is, it could be the husband, it could be the other party to the contract, we can make to the deed, which may be a friend, maybe their mother, their father. Once you find out that there has been a death, request a copy of the deed. Ask them if they have a will or not. Provide it to your title company or to your real estate attorney and let them handle it and let you know if there's going to be a probate proceeding. At that time, I don't request that you list the property until you know what's going to happen, because the last thing you want to prevent, the last thing you want it to happen is that you go into contract and you have to go to probate. Knowledge is power. So the more you know, the better it's going to be for you. When you're speaking to your seller, and your seller tells you, I'm going through a situation, whether it's a divorce, whether it's the death of a party, and you let them and you ask them for this information, that makes you look knowledgeable, and it builds even a stronger relationship. And you help the client navigate the process. As an attorney, I always request that the client give me authorization to speak to the real estate agent. And I usually get the real estate agent involved in the process so that the real estate agent can also speak to the client, keep that relationship going, and get that listing and be able to sell a property. So they help them navigate the process, and they will remember that for the rest of their life. I have clients, realtors that have kept in contact with me and kept in contact with the client, been involved in the process. And for the past 5 years, they've been their client. So they haven't lost that contact. And last but not least, always contact an attorney, keep in contact with your broker, and get the authorization from your client from the beginning to be able to get that divorce decree, to get all that paperwork to be reviewed by your broker and by the attorney. So what are other issues that I've seen this year with the realtors are facing is trust. So I've had realtors tell their clients that they have to go through a probate proceeding because the deed says that the property is in a trust. This is not necessarily true. A trust is a way to avoid probate. And so it's an estate planning, and an estate plan also includes a trust. So giving that advice to a client is the unlicensed practice of law. So no, just because you see the word trust doesn't mean that the client is going to go through the probate proceeding. So you want to have that you want to request a trust documents yourself, ask for authorization to speak to an attorney, and speak to an attorney yourself. The other issue is deeds. Like I said, be wary of advising your clients, oh yes, you can buy the property and then you can, just quick claim it to this person and quick claim it to that person. Be very wary, because buyers and sellers both are calling attorneys and wanting to file complaints because they got, just to give you an example, last week I had a client that bought a property. She was coming from South America, and she told her real estate agent, I want to buy the property, but I want to make sure that the property is going to be mine and that my husband is not going to have any rights to this property. And the real estate agent said, yeah, that's fine. After you close, just have him sign a quitclaim deed. And when the client called me, because she was advised by 2 other attorneys, and she wanted to confirm with me that this was the case. The case is, yes, even if he signs a quitclaim deed, that doesn't mean anything. You're married, and a judge can still decide that he has 50% rights in that property. That is not for me to decide. That is for a judge to decide. And so immediately she said, how can I file a complaint with the DVPR? Because I spent all this money, which was my money, in my country. This is my money. And so now, because I am bound by this property in Florida, I have to abide by Florida law. So be wary of giving your clients deeds. When telling clients to set up an LLC, real estate agents don't understand that an operating agreement is not required in Florida, but they're extremely important, because if there's not a will, usually I always ask for an operating agreement of that LLC, because that tells me who the owners are. An LLC has members, not owners. So just because there's 3 members on the Sunbiz, usually people go on Sunbiz and they say, let's be owners, and one is the managing member, the other one's a member, the other one's a member. That doesn't tell me who the owners are or what percentage they own. So, and that's set forth in an operating agreement. An operating agreement will also tell me how this will be distributed in case of the death of one of the owners. And so if there's no will, and it's an LLC, the second thing I look into is an operating agreement. So when telling your buyers or your sellers to create an LLC without an attorney, you're in the risk of not giving them the proper advice, because if they are setting up an LLC and there's multiple owners, there's no operating agreement, they're going to be in the same issue with probate. So don't cross the line. Again, and I want to emphasize it because I see it every day as a real estate attorney, issues with real estate agents, unfortunately, and it's all because of knowledge. So it's just a phone call, a question away. You build your relationship with the attorney, you build your relationship with your accountant, and you avoid all of these issues. And so that was a quick one-on-one. Now I'm going to be, I'm going to be taking questions. I'm going to start sharing my screen. If you want a screenshot to have my information, I'm going to stop sharing so I can take any questions that you may have.
I have a question, Gretchen. Someone has asked a question, will it be emailed to us? There weren't a lot of, do you mind emailing us that?
No, I'll do a copyright and I'll send it. That's okay. Fine.
There weren't a lot of, it was mostly like bullet points that you talked about, so that they didn't give a lot of lot of answers on the PowerPoint. So we are, you will be able to, yeah, we need the best way to contact you, and that your contact information people are asking for again. That's more important than the PowerPoint, but that'd be great.
Okay, so here it is. There it is.
Perfect.
Hi, I had a question, if you can hear me.
I can hear you.
Okay, and I was used to Maine law, so I'm still really fuzzy with Florida probate law. Is there a way, if you have something in probate, that the judge can sign off on it prior to the probate being completed and that proceeds being held in escrow and released after the probate, or do they not do that at all in Florida?
Okay, I couldn't hear the beginning. I heard if there was anything that we can do before probate.
Yeah, if something's in probate, can you approach the judge to go ahead and sell the property prior to the probate being completed, and then the funds be held with the probate attorney and released when that's completed, or do they not do that at all in Florida?
No, in here we have to start the probate proceeding first because we have to appoint a personal representative.
Okay, thanks.
Personal representative appointed. The will has to be, if there's a will, it has to be admitted and approved by the judge. And so it takes about 2 to 3 months before. It's just with the pandemic, because at the beginning it would just take a couple of weeks before we get the letters of administration and the PR appointed, and then we will be able to request an order authorizing the sale of the property. But now it's taking a little longer because of they're backed up, the courts are backed up. But no, I know in other states they do that, but not in Florida.
Thank you.
You're welcome, Karen. Sonia?
Yes, thank you so much for the information. And I was a little bit late to this to this video, to this Zoom. I don't know if you gave like a couple of questions, to ask to the sellers just to find out their situation. Did you give that information on your PowerPoint?
No, I did not. So, but when you're giving your listing presentation or when you're remember, this is a two-way relationship. They're contacting you because they want to sell the property, but you also want to make sure that you're the right real estate agent and that this is the right client for you. So you want to interview your client as well. So, I know that in this market people are rushing and trying to compete to get listings, but you want to get to know your seller. And so you want to ask these questions. My real estate agents usually have me draft a document that their client fills out, depending on what they want to know, like status, their name, last name, their marital status. They request a copy of the deed, and then they have me review all of that before they sign the listing agreement with this client, because they face these issues. So after a real estate agent goes through an issue like the ones that I mentioned, they usually will try to cover themselves going forward. So if that's something that you want to do, contact me and I'll be happy to help you draft a form so that you can have your seller fill it out or your client fill it out. And if they're married, the next question will be, where's your husband? Are you separated? And then I'll provide the legal advice. You don't want to tell them, then you can't sell a property on your own. You always want to say, well, can I get a copy of the divorce decree? Because they will tell you, no, I'm single, I'm separated, he left, we haven't talked in 20 years. And they think like that's dissolved, but it doesn't dissolve. It doesn't matter where the husband or the wife is. If they are married under Florida law, if there's no divorce decree, they are legally married. So contact me and I'll help you draft one of those forms so that you can have to ask your clients the right question.
Excellent, thank you. And I have a second question. Right now, people, especially here in Florida, with the salary here in Florida, it's kind of challenging for them to purchase a property. And sometimes they use right now their mother or somebody else, right? And let's say that there's like an echo. Let's say that one of the mother, right, that helps the couple says, I'm going to be a non-occupant and I'm not going to be on the contract. What happens when they want to sell this? Will she be part owner, or how does it work? Or is that like a very specific question that is like a consultation?
Yeah, you're saying if the mother is the one purchasing the property on behalf of a son?
No, let's say that just the couple is going to be signing as the owners, and she's going to be a co-signer to them.
So if they're co-signing, there shouldn't be an issue. Now, in the past couple of months, I've had a lot of issues where the purchasing party and that's financing the property, it's not the owner. It's not going to be the owner. They're buying for either their son or their daughters or whatnot. And then after the closing, they do a quick claim deed to the right owners. But what you have to understand is that because that's the advice given by the real estate agent, which you don't want to get into, because what's happening is lenders are catching up to this. And I've seen affidavits and that this buyers are signing where it says this is going to be your primary residence, and we reserve the right to accelerate the loan if there's a quick claim deed or if it's transferred to an LLC. So you want to look at all those documents, and you want to, as soon as you encounter that issue, just better get your hands off and just have an attorney deal with it.
Okay, thank you so much.
Hey, Gretchen, let me pipe in here. We got a couple hands up, but Zoe was first. Zoe, go ahead with your question.
Hey, it's kind of a story and a question at the same time. So my parents, and sorry if you can hear my son yelling in the background, he wants me, but my wife's got him. My parents had their their lot quit claimed away fraudulently, and we had to go through a long quiet title case to get it back. It took over about a year. And I was wondering if that was when it comes to a fraudulent, I don't know if this is in probate or not, but when it comes to like a fraudulent case like this, where it's like they never signed the quit claim deed, but this guy quit claimed it over to himself and then to another person, to a wholesaler, and then they sold it. And then we had to do a quiet title suit to get it back. I was wondering if we took the right route by hiring a lawyer and doing a quiet title suit where it cost us over $5,000, or if there's some other avenue to get that property back.
So that is it's a very particular situation. So we'll look at all the factors. Based on what you're telling me, if it was fraudulent, the quiet title action would have been the right route. It's definitely not probate. Probate is anything that happens after the death of a seller or a party. That's when the probate proceeding begins. So anything fraudulently, well, you have two cases. You can have a civil case for fraud, real estate case for fraud, fraudulent transfer, and you can have a quiet title action to fix the title issue. So, but it's very particular. So I would need all of the factors and everything that occurred and review all the documents to be able to give you a straightforward answer. But if you spoke to an attorney and he went with the quiet title action, and $5,000 seems about right.
Okay.
So they're very expensive.
Thank you so much.
I guess you can go through the hands up top if you want to start with Martha. Gretchen.
Okay, Martha.
Yeah. Hi, Gretchen. Thank you for having us, I guess. Question, and I'm not sure if I'm asking the right person, but it sounds like it is. When a transaction on the buyer's side, I'm the buyers, I have the buyers, I'm the buyer's agent, and we have this house that we put an offer on, and it looked like it was under probate. And I even asked the agent, was all that stuff resolved? Is it ready to sold? He said yes. Of course, when we sent the offer and they told us very well yes, it turned out to be a whole bunch of things. So my question is, and since you know real estate as well, is that something that the agents, that we can get our hands on it as a buyer's agents before we're wasting all this time on an offer that we don't know what's going on in the back end on the other side? Does it make sense?
So how did you find out that it was in probate?
Well, I look at the records and it says the state of such and such. So that's why I asked him. I didn't know what kind of.
So how was the contract? The contract, how was it written? Because usually it would say personal representative. That's the correct way of listing a property if it's in a probate proceeding. Did it say personal representative?
No, it just said the state of the person, and that's what I put in the contract because I did check with the other agent.
So if they have an order authorizing sell, they can sell the property even if it's in a probate proceeding. That's why I tell all my real estate agents, stay in contact with your client, because as soon as we get the order authorizing sell, you're the real estate attorney that refer the case to us. We're going to tell you to list the property. So we usually go ahead.
And as the buyer agent, can I ask that from the seller's agent? Because he seemed kind of like, he said yes, but.
Yes, you can. If you see an estate, you want to say, before we waste our time, can we? Is there an order authorizing sell? Usually, they will tell you yes because they can have the estate. So the listing agent has to be in contact with an attorney because usually listing agents don't know how to put it on the contract when selling a property that's in an estate. So if they are speaking to it, if they already have an attorney and they're already listing the property as an estate, then they usually have the order authorizing sell. And you can definitely confirm that the judge has signed the order so that there's no delays. Usually I won't have my agent sign the or fill out the listing agreement or the listing contract until I get the order signed by the judge. So until I have it in my hands, because it can cause delays. If I tell my client, yes, go ahead and list the property because I know the judge is going to approve this, even if I file the order authorizing sell, I will not get myself into that situation either until I get the document in hand. So yes,
Right, thank you.
By all means, confirm. And by all means, if you see, now that you have this information, if you see a contract that has just one name and it doesn't say a single person, a married person, or anything like that, then ask, is the seller married? Look in the records, or don't even ask, go into the records and find the deed. If there's another person's name on it, why isn't that person's name on the contract? See, these are all little things that you as an agent can do to also protect yourself if you're on the buyer side.
Right. Quick question just to finish. So in that note, I did found through the records that there were like 5 people signing this that were supposed to be signing, and I saw a whole bunch of records or whatever. But in that case, if any of those 5 people are married, then that person is also supposed to sign, the husband of that person that's on that.
If it's an estate, only the personal representative signs on behalf of the estate.
Okay.
One person is going to be signing.
Thank you.
You're welcome. Mike? I guess Mike's not there.
No, sorry. Yeah, sorry. I just had a moment to get myself unmuted. Yes, through the years, going on public record and looking at properties, whether I represent a seller or the buyer, most often we see a lot of the quick claim that are recorded there. And I guess my question is twofold. Also, we see like there's $100 that's charged for it. And then what I have, we see some buyers coming in that are unmarried couples, 2 different people, and they want to know how their names should go on either the contract and or on title. And most often in my ignorance, I've just told them, well, you can do a quick claim after the fact, this and that, get title company involved. But I guess my question is there a procedure, a name for procedure that you do, or a certain cost involved to, let's say I represent either buyer or seller, and we want to verify what that quick claim is, if in case it will in fact cause problems with the contract going through and closing?
So one of the things that I'm going to say is that this generation, the millennials, millennials and the centennials that are buying properties now too, they're not buying, they're not getting married, or they're same sex and they're taking title. They want to buy properties, and that's one of the first questions that they ask the real estate agents: how do I take title? Don't that's not for you to answer because you have two people that are individual, and each of those individuals are going to have different tax situations. So you don't want to tell them, oh yeah, go with this joints with tenants with right of survivorship, or go with tenants in common. You don't want to tell them how to take title. Never get into that situation because there's two individuals, and there's just too many factors that come into play when you're advising your clients. Plus, you're crossing the line of the unlicensed practice of law. So what you want to do in that instance is have them contact their accountant or an attorney and have them deal with that. Don't get into advising them. The second part of your question is when you see, don't ever advise after. You can do a quick claim deed because that also has issues. And one of the things that I find with real estate agents that they don't know is that they'll even have a friend or help the client with drafting the quick claim deed. That they get one online, they download it, and then they file it. Well, guess what? There's doc stamps that have to be paid if they're not married. There's doc stamps that have to be. That's if you're taking one person off or adding one person. It all depends in that situation how much those doc stamps are going to be, and they could be in the thousands. And if that's not paid, there's a 10% penalty that the state charges. I had a client that had a quick claim deed, never paid the doc stamps, and it was 3 years worth of the 10% penalty. And this was all due because of the real estate agent telling them to do the quick claim deed, and they even filed a quick claim deed for the client. So don't get involved in any of that. When you see that situation, immediately just contact an attorney, well, the broker first, and then the attorney. But don't get yourself into advising anyone how to hold title. And the title company should not do that. I've seen emails where they forward me the emails. The real estate agent forwards me the email where the title company tells them, well, they should hold title this way. Title companies are not attorneys. They should not be getting involved in that either, because they're crossing the unlicensed practice of law. And so it's a fine line. And we see real estate agents suing title companies because of the same issues, because they got into a problem where because they were advised by the title company. The only one that can advise on behalf of a title company is an underwriter, and they usually will not engage in telling you how your buyer or how your seller should do things. They would advise the title company on how to clear their title issue. That's it. They won't engage in anything else. So I wouldn't advise any agent to get involved in advising their clients on that.
Thank you.
Leanna? Leanna?
Yeah.
I can't. Do you have a question?
Yes. Hello.
Yeah, what is your question, Eliana? We can hear you. What is your question?
I'm sorry. Yes, I've been working on and off with a homeowner that he jointly own a house, and with his ex-wife. She passed away a year ago, and they had 2 children. And I would like to know, is this a probate case? Because she passed away and they were married, but now he's divorced from her, and she passed away. There is no will.
Yeah, Liana, that will require a consultation because I will have to review all of the paperwork in order to be able to give you an answer. And that's not even a definite answer because it all depends on how the divorce decree was drafted, who the property was given to, if the transfer was done properly. So that answer requires a consultation because I have to look into the particular case to give you that answer.
Okay, thank you.
And then last, is it Rishu?
Thank you.
You're welcome.
So, hi, how to book a consultation with you? That's my question is.
So you can call our office and they will book a consultation, or you can send an email to info@GretchenOrtizLaw.com, and that will go straight to my assistant and she will book a consultation.
So it's going to be a Zoom call, or it's going to be a face-to-face?
I mean, it all depends. We do Zoom calls, phone calls, whatever works for the client. Usually, they all work the same.
Okay, thank you so much.
You're welcome.
Gretchen, do you mind doing Tammy's question, and that'll be it?
I can't see Tammy.
She's got her hand up. She's in the you can't see because her camera's on. So Tammy, go ahead with your question.
Okay. So I just met with some people yesterday. He is on the public record as the owner of the home. They are married. So why would that wife be on the deed, or why would married people end up being on the? Is it just because the loan was in his name, so they didn't put the other person? It was a new build when they bought, but they are married.
Okay, so they are married. That's okay. So they are married, and this is their primary residence.
Yes.
Okay, so. Even if one of the parts, so what is your question? They're both on the deed?
My question is, would she be on that deed or not? Like if you're a married couple and you buy a house, but you only buy it in like the husband's name, the wife would not be on the deed?
I have a closing this afternoon where the wife is buying the property under her name, but she's going to be as a married woman. So that doesn't take the rights away from the husband.
Right.
So she's just financing the property under her name, but it still doesn't take the right away from the husband because that's going to be their primary residence. So they're still covered by the entirety.
Correct.
So
and she will have to sign.
Yes, and he will have to sign off on the mortgage because there's going to be a lien on the property. Mm-hmm. So he will have to initial, unless it's cash, he will have to initial and sign off on the property.
Well,
because
they're selling their house. So but they're married, but he's the only one in the public record. I have to go look at the deed. But anyway, I have another question. So I have a fiance and a guy and a girl. They're going to get married in February, and the mom is going on, which I told them they need to get in touch with an attorney to figure out how to take title. So in a situation where you have two single people, but they're going to be getting married in a few months, once they get married, does the way they take title change automatically because of the marriage, or what's that situation?
The default tenancy in Florida is tenants in common. So every agent should do this. That's the default. So if they don't know how to take title, default is going to be tenancy in common, and title companies will usually do this. They won't even get into the tenancy. But as soon as they get married, that's their primary residence. It creates a tenancy by the entirety. So even if the title doesn't say a married person, because when they bought the property, they weren't married. As soon as they get married, it's going to be it's going to become a tenancy by entirety. So that's another reason why you want to make sure if you want to ask if your seller is married, because they won't tell you. If the title tells you, if the title says just the name of one party and the other one, and you assume it's a tenant in common, but they did get married but are now separated, and you sell that property, you have an issue, which I've also seen. So
they should talk to an attorney about how to take title because it's a mom.
You have to understand, with everything that is going on, people are dying very, very young. And so getting married in 3 months is not going to protect them now. If something happens to one of them, car accidents, anything happens, they're not going to be protected now. So from this moment until the moment they get married, that title, they need to have the proper title to protect them. That's when they want it.
All right, everybody. Thank you, everyone. Thank you, Gretchen, for taking all the questions. I think, Gretchen, maybe you can just answer this last question for me. You have given us some good things to look for, given the agents some good things to look for when I think they may have a probate issue or anytime it's going through probate. And it seems like everything kind of comes back to Do not do any unlicensed practice of law. This is very serious business, and consult an attorney, either Gretchen or someone else. She's not just telling you just Gretchen, but consult a real estate attorney. Gretchen, of course, would be a great choice. So Gretchen, anything else you want to tell them, how to reach you, the best way to reach you? What would you like to tell them before you go?
Email is the best way, info@GretchenOrtizLaw.com, because that way my assistant will get back to you immediately. If you have just a simple questions, which I always do this for FRI agents, and you have a simple question, understand if I don't have a consultation with you, I can't give you any legal advice and tell you how to proceed. But if you have a question as to, hey, there's a death, do I need to go to probate, or can I list this property? I can usually answer a question like that. And you can just send me a message, send me an email, send me a text, and I will answer that question. Now, I can't take a whole case and give you legal advice, because I need to look and review documents and go through the whole process to be able to provide legal advice. So the fastest way to get in contact with me will be through email.
Well, we really appreciate that. Thank you so much, Gretchen. This has been very informative. And the biggest thing we learned is that we don't know anything. So that's good. and we don't want to mess it up, because it's very important. So thank you very much for everything. Thanks for coming in. And it was great to see you and to hear you. And we really appreciate you. And we'll be reaching out. Thank you very much.